Hey guys, I wanted to shoot a quick video and educate you as to a particular labor code called Labor Code 3352H. Today was day 3 of a trial I had. Essentially, this labor code is what's referred to as a babysitter exception. So when you have a potential employee that is performing maintenance of a residential dwelling and or babysitting towards that residential dwelling, there's a potential caveat or an exception that excludes them from being an employee. So first, if you want to know if either a babysitter or somebody helping at the residence is an employee, you first want to look to Labor Code 3351D. Labor Code 3351D defines a residential dwelling employee, and it states, except as provided by subdivision H of section 3352, which we're going to discuss, any person employed by the owner or occupant of a residential dwelling whose duties are incidental to the ownership, maintenance, or use of the dwelling, including the care and supervision of children, or whose duties are personal and not in the course of a trade, business, profession, or occupation of the owner or occupant. So essentially, somebody at your house performing maintenance on the house or babysitting is theoretically an employee, and you need to have workers' comp insurance for that person, except Labor Code 3352H has a specific preclusion that says if you've worked less than 52 hours in the 90 days preceding injury, you're not an employee. If you've earned less than $100 in the 90 days preceding injury, you're not an employee. Essentially, this is like what we refer to as the babysitter exception, right? The state wants homeowners to be able to hire babysitters, have them babysit, or hire somebody to do routine maintenance or something like that on a house, and it not be an employee. So there's a statutory preclusion under Labor Code 3352H if you can show that this person worked less than 52 hours in the 90-day before injury or earned less than $100. Now, the reason I'm going over this with you is this is one of the most heavily litigated labor code provisions at the Workers' Comp Appeal Board, because essentially I have somebody who's injured, I file a claim, the insurance company is going to deny it, and they're going to say they're not an employee, and they're going to cite to this labor code. Today's trial was day 3, where essentially I was arguing, one, my client worked more than 52 hours in the 90 days preceding injury, earned more than $100 in the 90 days preceding injury, and this is always he said versus she said, so they always put on evidence to indicate otherwise, and then you have to put in your testimony, pay stubs, checks, statements to try to argue that the client worked over 52 hours and earned over $100 in the 90 days preceding injury. But also there was something very clever I did in my trial, which ultimately just got approved today. So day 3 of trial, and the defendant has voluntarily picked it up because at the particular dwelling that the injury occurred, I argued that they also rented that apartment complex out, or that house out. Now, if it's a rental property or income property, then essentially what happens here is I argue it takes it out of the residential employees exception, because Labor Code 3352 and Labor Code 3351 is for residential properties only. So very cleverly, I was able to show that because the property was used for both residential and commercial, that irrespective of Labor Code 3352's preclusion of employee under the residential residential exception, that my client was an employee because it was also a business location or a commercial property. Now it gets even more complicated because these houses have homeowner policies, and depending upon this specific homeowner policy, it may contractually void a workers' comp policy if it's commercial. Very complicated. This is why you definitely want to have an attorney. So if you're a babysitter or a nanny or a caretaker, and you were injured during and it arose out of and was within the course of your employment with a residential property, you may have a valid claim for workers' comp benefits. You need to speak to an attorney. Feel free to give us a call.